Hi, guys. This is Attorney Tay with Thinking with Tay. Given the current discussions centered around the Voting Rights Act of 1965, I wanted to share my thoughts with you. The Voting Rights Act is a landmark federal law signed by President Lyndon Johnson on August 6, 1965, in an effort to remove voting restrictions that were implemented by various states based on race, as well as to remove legal barriers at the state and local levels that effectively denied African Americans the right to vote, a right afforded to them under the 15th Amendment to the United States Constitution. The 15th Amendment was enacted in 1870 and in summary states that the right of the citizens of the United States to vote shall not be denied or abridged, in other words, cut, reduced, or lessened by the United States or by any state on the basis of race, color, or previous condition of servitude. In other words, enslavement. However, despite the passing of the 15th Amendment, challenges with African Americans' efforts to vote ensued, and discriminatory policies and practices, including but not limited to poll taxes, literacy tests, among other Jim Crow laws, were implemented, as well as violence and intimidation by other citizens to impede African American citizens' efforts to vote. The Voting Rights Act banned literacy tests and other policies and practices used by states and local municipalities to disqualify African American voters in their attempts to vote. Despite the enactment of the Voting Rights Act, challenges still remain. For example, on June 25, 2013, in the Shelby County versus Holder case, the United States Supreme Court, in a 5-4 decision, struck down essential provisions of the Voting Rights Act, ruling that it was unconstitutional to require states with a history of voter discrimination based on race to seek federal approval or pre-clearance before changing their voter and or election laws and policies. As a result, a number of states passed new restrictions on voters, including but not limited to voter ID requirements. Some opponents conclude that these such restrictions result in voter suppression, which negates the purpose of the Voting Rights Act. And some proponents of the restrictions assert that such restrictions help to reduce voter fraud. What do you think about the Supreme Court's ruling to no longer require states with a history of voter discrimination to seek federal approval or pre-clearance to change its voting and or election laws and policies? Now remember, I'm not telling you what to think. I'm only asking you to think. Until next time, goodbye.